Hello, everyone. Thanks for joining us for today's episode of Subro Sessions titled Speak Now or Forever Sign That Release. My name is Sara, and I'm a partner in the White and Williams Subrogation Department.
My name is Lian Skaf, and I'm a partner in the subrogation department also.
So, as evident in the title, today's topic is about subrogation settlement releases. These agreements are essentially required every time a subrogation claim reaches a settlement before a verdict or a judgment. Before the target or defendant agrees to pay the settlement, they want to be ensured that they are forever free and released from claims related to that incident. And while everyone generally agrees that a release needs to be made, there are often disputes as to the language, scope, and sometimes even the format of the settlement release. And not only can these disputes cause severe headaches for everyone involved, they can also sometimes risk the entire settlement falling apart. So today we're going to discuss releases generally, the typical issues that we tend to run into, and some advice for potentially dealing with those issues. And because this can be a lengthy and extensive topic, we will be breaking this episode into a two-part series. But we're going to start with today's episode with discussing who drafts the release. Which party is in the best position to propose the draft release? Leon?
Yeah, and before we get into that, just to extrapolate on what Gus was saying. So, this first of two episodes is intended to be kind of a primer where we discuss some of the issues generally, and then we'll get more into more specific case law or some more stories in our second episode to really apply what we're talking about today. So, who drafts the release? Essentially, we're talking about should it be us as the subrogation attorneys or professionals or the defendants that are being released? I think it's pretty much the consensus from our end that if we can control the terms and how we're drafting the release, that's something that we want to do. I always propose drafting it. We have, different releases for different situations we can kind of use as a template and work from there. So, that's usually my first shot there is to say, let me give it a shot. These are only proposed terms. You're free to offer suggestions, additions, subtractions, and we can work together for that. It's not always that easy. Sometimes the other side will say, no, I'm required that we use our template, or I want to give it a first shot, and I'm generally okay with that too. I mean, this is something that we need to agree on. We need to agree on the terms from both ends. So whether or not they start or I start with a draft, I'm not going to agree to something that doesn't work for the client anyway. It's just a little bit easier to kind of get your side and your version out there first to work with that.
Yeah, and I will say it's becoming more and more common for the other side to want to draft the release, whether it be the liability adjuster or defense counsel. In those situations, I at least try to immediately identify some absolutely nots and things that I know the client won't accept as an attempt to preempt those being included in the first draft, such as indemnification language or certain types of overly broad confidentiality provisions. But we'll talk about those a little bit more later.
Yeah. So a lot of times, especially when you're dealing with big corporations or companies that are the releasees, they have a template, a document that they say, this is it. This is what we always use. We can't deviate, etc. In those, cases, that's not going to work. We're not going to just take it or leave it release with that language. I generally will try to get to a general counsel if I can, because, if we're dealing with third party adjusters or even in house adjusters, they have marching orders. They don't really have much leeway when it comes to that. But I find that if you are able to get to a general counsel, they're much more understanding that, look, this is a negotiation and you can't just give something and expect they're going to accept every term.
And that's a good point because some carriers have fill out forms where they can only put in certain aspects of the case, such as the address, the date, and the parties, but they can't modify other aspects of that document. So if we need to edit a sentence in the PDF document, the carrier will sometimes tell us to just handwrite it. And then it could be a whole messy document by the end of it, because then you have to scratch out a sentence, cross out some lines, write in the margins, and then have the client sign it. And it's just not a very formal looking document. So that's another reason why it's probably best to try to edit or draft the document yourself. Okay, moving on to the actual structure of the document, we're going to start with titles and then prefaces and preambles. Now, with the title, it's my position that every aspect of the release can be impactful, including the title at the top of the document. If there is ever a dispute over the terms or enforceability of the settlement, then most, if not all, jurisdictions will consider the intent of the parties. And every word of that release will then become relevant, including the title. So, what do we call the document? The title should describe exactly what the document is and nothing more. And my intention is always to try to make the release as narrow as possible, limiting the release to the specific event and to only claims that my client has with respect to that event. It's not always possible, but that's my goal. So I don't like language such as general release or release of all claims in the title. I try to make the title as minimal as possible, such as release or settlement agreement.
Yeah, and just to play devil's advocate, as a young attorney and as a young subrogation attorney, one of the things I remember being hammered home was exactly what you just said, Gus, was we never want to see general release, global release, these kind of broad stroke terms. And, that's fine. And it is important. Again, I'll say though, I've never had anyone even mention a title of release to me in any context, let alone try and use it as a challenge to the substance of the release. I think if something was challenged and you were in front of a judge, I can't imagine a judge saying that, despite everything else that's in the content of this release, because this one provision says general, I'm going to say that you've released everything under the sun. Now, if a judge is crazy enough to do that, I think that's easily appealable and overturnable. Of course, the practical point there is, do you really want to go through all that? No. So it's just as easy to do what Gus is saying here and keep the title as narrowly strict as the rest of the release content. So after the title, what comes next? As lawyers, I feel like we like to begin our documents with these kind of grand intros. We love legalese, we love Latin terms, all that kind of stuff. It reminds me of a Jim Gaffigan bit I heard once where he talks about hiring an attorney. And, he says, I'm essentially hiring this guy just to read this document. He starts to read the document. He says, where to for, you know what, you do it. I'll pay you $2,000 an hour. Sounds reasonable. So I don't know if we need all this fluff that's coming up to begin a release. I really would stray from it, just kind of get to the point, and start talking about the actual particulars of releasor, releasee, and just kind of cut to the chase.
Yeah, and are they legally binding? Are recitals, preambles, prefaces, however you call it, the first few whereas clauses where you're setting the background, certainly necessary for the document to make sense, but generally they are not considered the legally binding portions of the agreement. But that said, they are very relevant if a settlement dispute arises. Going back to the title issue, if there is a dispute, a court is going to look at the intent of the parties, and consideration of the title and the recital is possible. If a court is looking into what the parties were thinking at the time they entered the agreement, they're going to consider all aspects of that document. And like Leon said, the recital is important because it provides a necessary background and a roadmap for the release to make sense. Now, going into a very, very important topic, inclusion of the insured in subrogation settlement releases. I don't know about you, Leon, but I'm seeing more and more that liability carriers and defense attorneys are requesting that the insured be named as a signatory to the release as well, even if we do not represent the insured, and even if the insured has not brought forth a claim. This has led to delays and disruptions of a few of my settlements in the past. Here are a few things to consider. Does the insured have a claim? If so, then presumably the insured is involved in the settlement and should be a signatory to the release. And if we represent the insured as well, then it's absolutely expected that they sign the release if it is a global settlement, which it often is. If the insured doesn't have a claim, then I usually try to push back. I inform the other side that we do not represent the insured and have not presented any claims on behalf of the insured, and that requesting the insured's signature on the release is unreasonable and unwarranted. If the other side insists, then I make an effort to secure the insured signature. In the instances where we need to secure the insured signature on the release, it is good to have kept an open communication with the insured. If you notify the insured of the subrogation claim and the settlement, then it should not be hard to ask them to maybe get involved in the settlement process and sign the release. It should not be a surprise to them that there is a subrogation claim out there. If you haven't discussed the claim with the insured since maybe the first party adjustment was resolved, then you could run into problems. Or if the insured is generally uncooperative and has been from the start of the subrogation effort, then getting the insured to sign the release may not even be possible. So, what do we do in those instances? If the other side continues to insist that the insured sign the release and a signature can't be secured, the following has worked for me. I've secured an email or statement from the insured that they do not have any uninsured losses. Sometimes the insured is uncomfortable signing a convoluted agreement with a bunch of legalese in it, but they'll be willing to write a short email or a short letter stating that they don't have any claims or interest in pursuing the target. If that doesn't work, sometimes the other side is even okay with me sending an email that I had a conversation with the insured and confirm that there are no uninsured losses. If that doesn't work, then you can consider a strictly narrowed indemnification clause pertaining only to claims brought by the insured. If you and your client are certain that the insured will not be presenting a claim to the other side, then it seems like a very, very low risk type of agreement. If the client is not okay with that, then you can consider entering into a tolling agreement and for the statute of limitations to pass, or at least agreeing with the other party to wait till just before the statute of limitations runs to limit the risk of exposure if you have to indemnify the insured or if the other party agrees to not have the insured sign the release under those conditions.
Yeah, I think the bottom line is you want clarity. If you're not representing the insured and if you're not including a claim from the insured in the release, you make it clear. Make it clear with the insured. Try and make it clear in the actual release. A lot of times I even propose language that says the insured's rights or that any claims are specifically not included in here. Oftentimes I don't get pushback on that. And if it is included, obviously, it needs to be clear too. All right, the next point we're going to talk about, we can kind of go quickly, is whether a lot of times the defense or the targets want inclusion of their carriers. Oftentimes it is the carrier that you're working with to get the terms of the release specified. The bottom line is I have no problem with it. If they want to include, XYZ insurance carrier as a releasee, I'm fine with that as long as it's very specifically referred to the specific loss that we're talking about. I have no problem with it. And again, it seems to be something they're very concerned about. So, you got to pick your battles.
Yeah, it doesn't make sense to me to name a carrier and then add insurers, reinsurers, which, they're in that category. But if that's what's required to get it done, I don't see it being a harm to our clients. So I typically agree. Now, the specificity of the loss description is critical. Sometimes I get templates from either a liability adjuster or defense counsel, and they're simply just referencing a date of when the incident occurred. There's no address, there's no details as to what type of incident it is. It's just a date. And that simply is insufficient. That is definitely not acceptable because the carrier could be releasing the parties for other unrelated claims that occurred that day. It also makes the document ambiguous, which could jeopardize the enforceability of the release. And a reference of the city and state is not enough either. I just like as much detail as possible so we know what incident we're referring to and what is being released. So we need to see the complete address of the incident, the type of incident, water loss, fire loss, roof collapse, and the date that that incident occurred.
Yeah, I think the easiest way I find to do that is to up in the front to set definitions. So loss, we put in parentheses and then give, the exact date, if you have a time, the location, so that you can keep referring back to that throughout the release without this, long verbiage. Just you can use the definition throughout. All right, the scope of the release. Are we talking about property damage only? Typically, in our subrogation cases, we are. Sometimes and oftentimes bodily injury or personal injury is not relevant. Sometimes it is. It's just important that, we have an expectation with the other side that what are we releasing? Again, sometimes it's not relevant at all. You have a pipe water loss, no one's home. Personal injury is not even something to concern. If for some reason they really want to include it, usually I'll talk to the client. We have no problem. But, in fires, it's obviously different. And when there are known bodily injuries, it's very different. And you want to be very specific that the release does not include that and that the scope is limited to property damage and oftentimes to property damage being paid through subrogation.
And that's another problem with a lot of the templates that we get from the other side. A lot of times they're tailored for personal injury actions. So they reference Medicaid, Medicare, liens, and things like that. And we try to edit those out because they're simply irrelevant. Another reason why having us draft the release is just a cleaner process. Now, indemnification hold harmless provisions. We're going to go into this topic in more detail on during the second episode, but this is essentially worst case scenario situation where the liability carrier or defense counsel is requiring that we go beyond releasing the claim, but that also the claimant cover any expenses and judgments for any future claims or actions brought against them regarding the incident. That is a very tall order, and subrogation carriers are usually extremely reluctant to accept such terms. And sometimes these provisions can be narrowly tailored to certain liens against the first party claim or claims brought by the insured. And sometimes they could be very broad and refer to any claim by any third party arising out of this incident, which can be increasingly problematic. Again, we're going to go into specific examples and some life experiences where indemnification and hold harmless provisions became an issue in settlement negotiations.
Yeah, and I'm going to move on to a topic that I think a lot of times is important to the liability carriers and the defendants that not often is important to us. Again, a lot of this is kind of trade offs here. Indemnification is important to us. The scope, including the insured, is important to us. Confidentiality clauses, usually not that important to us, but they are to the other side, which makes sense. We're alleging something that, they did wrong, whether it's through work or a product, and they don't want that information out there. I get it. If I was on their side, I would probably think the same thing. So, we just have to be careful about what language we're agreeing to. We can't talk in absolutions. Oftentimes they'll say, well, except for only legal or this. No, we represent insurance companies. This information is going to pass through a few hands in the normal course of business and insurance. So as long as I have that language in there, which generally I find the other side to be fine with, I think that kind of satisfies all parties. Again, with some of the bigger companies, they often want anti-disparagement clauses, which kind of falls into this category too. Saying I won't go on social media, I won't go online, I won't rip your company. Again, obviously, we're not going to do that. The clients aren't going to do that. The only thing I would warn is that if the insured is included, make sure they know that as well, because sometimes insureds, whether it's out of frustration or they just don't know, will go give a bad review and might run afoul of some of these terms here. And obviously, you don't want that to blow up.
And lastly, for this part, we're going to discuss signatures. Who signs the release? I've seen a lot of releases where only the claimant's signature line is present, and the other side, the target defendant, if you're in suit, does not have a signature line. I've seen it work both ways. I prefer that all parties to the settlement sign the release, but sometimes you'll see just the claimant's signature line, and that is typically enforceable as well. If the claimant needs to sign the release, I typically have a representative of the subrogation carrier sign the release. Sometimes, if we're on a time crunch, the carrier will authorize me to sign the release as an authorized representative of the carrier. I personally think it's cleaner to have the carrier sign it directly, but I have done that in the past when time was an issue. And if for some reason there is no signature or it never gets executed, or the executed version is for some reason lost, there are cases that suggest that the settlement will still be enforced, obviously, because there was still the intent of the parties to enter into a release. And in the next part of the series, we will discuss some cases where the release was not executed, but the court still enforced the settlement.
Yeah, and now we're kind of at the end. I want to go back to the kind of beginning for a moment. Are releases necessary? Again, almost always the other side that we're releasing wants one, and that's totally acceptable and reasonable and practical. But I've had situations where they said, "Nah, I don't need a release. We're good." My opinion is I still want that release. I still want terms spelled out, which seems kind of antithetical since we're the ones releasing rights. But everything we talked about, whether that includes the insured, what's the scope, et cetera, when you don't have a release, it leaves that all open to interpretation. And I don't want that. I want it to be very specific about what's going on here.
Agreed. It's nice to have closure.
That's right. All right. As Gus mentioned, this is the first of two episodes. The next one, we're going to dive in a little bit deeper. Thank you for listening to this episode of Subro Sessions. You can find past episodes of the podcast on the White and Williams homepage, www.whiteandwilliams.com. Hover over the Insights link and select podcasts to find past episodes.
We would like to remind everyone that the contents of this podcast are intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation with respect to any specific legal question you may have. The podcast should not be construed as legal advice for a particular situation or to give a legal opinion on any specific facts or circumstances. Prior results do not guarantee a similar outcome.